This is Chapter 2, Part 2, the role of the courts. Chapter 2, Part 2. Let's look at slide 15 and talk about Marbury versus Madison. The Supreme Court reviewed a law involving the appointment of federal office holder Marbury. The president at the time, Thomas Jefferson, refused to give Marbury his job because of political differences. The Supreme Court declared that Marbury could be entitled to the job and that they could order the president to do so, but the law establishing the position was unconstitutional. This created the doctrine of judicial review, the power to declare a law unconstitutional. So that's the case where that came from. Slide 17, impact of case law. When an appellate court decides how a law should be applied, it is called a precedent. Under the legal doctrine of stare decisis, precedents are binding on future court decisions. So, and you've probably heard that before, where a case goes to court and a precedent is found. Those are really important in an appellate court because that does set the standard, that sets the stage for future cases coming, so it sets a precedent. Let's look at page 33 at the bottom. A higher court can vacate or reverse decisions of courts below it in the organizational chart. We already looked at the organizational chart. If this has not occurred, an appellate court can overrule its own earlier decisions. When there is no precedent set, a judge may consider cases that are not binding on the case, such as out-of-state cases, or those from other appellate districts, and they can make a similar ruling. So this is where attorneys really rely on their law clerks to help with research and knowing different, and good attorneys doing their own research as well for these precedent cases or cases that are similar. Let's look at slide 18, evidentiary standards used by the courts. Contemporaneous objection rule. An objection should be made before an answer. Let's look at your textbook, page 34, to understand that a little bit more. Evidentiary standards by courts, page 34. Courts review evidence based on several different standards. Next paragraph. The first step in the review process is triggered when opposing counsel makes an objection. That's when it gets reviewed. Otherwise, it wouldn't. Bottom of that paragraph. The appropriate timing for the objection is after the question is asked, but before the witness answers. This is called the contemporaneous objection rule. Let's look at the top of page 35. In some situations, the objection is so obvious that the judge rules on it instantaneously. More commonly, each attorney is allowed to assert reasons or arguments why the objection should or should not be sustained, after which the judge makes a ruling. During the pretrial stage, the judge I want to talk about that right now. Yeah. During the pretrial stage, the judge may be called upon to make a variety of rulings on evidence. This review may rely on facts that may not be admissible at trial because of the hearsay rule, which we'll talk about more in this textbook, the exclusionary rule, or other technical reasons. These initial reviews require the prosecution to show that there is prima facie case. So that is, a judge must consider if a minimal amount of evidence is present. It's enough evidence to allow the judge to infer that the fact at issue and rule in the party's favor. Preponderance of the evidence. On your slide 18, the prosecution must show proper procedures were followed. On page 35, right in the middle, suppression motions are usually heard before trial. The judge will hear testimony about the procedures used by the police to seize evidence or obtain a confession and rule on the defense's request to exclude the evidence from trial. The prosecution normally has to establish by a preponderance of the evidence that the procedures were conducted properly. So it's not a beyond a reasonable doubt, but it's preponderance of the evidence. It's a greater weight of the evidence. All right, beyond a reasonable doubt, slide 18. To convict, a prosecution must prove guilt, but reasonable doubt is not any doubt. It's just beyond a reasonable doubt. Top of page 36 of your textbook. Beyond a reasonable doubt defined, it's proof that precludes every reasonable hypothesis except that which the law requires for the case. So the key word is reasonable, and you've heard that word a lot already, and you'll hear it a lot more in this textbook. Let's look just below that. Probable cause is defined as more likely than not, and that is requires at least 51% certainty. Probable cause is 51% certainty. So it's beyond the majority. To meet beyond a reasonable doubt standard, the facts would need to establish very close to 100% certainty that the defendant is guilty of the crime. So you see the huge difference? Probable cause is 51%. Beyond a reasonable doubt is close to 100%. Important to keep in mind. And let's look at slide 19. Post-conviction proceedings. I think this chapter is a really good foundational chapter for us. Post-conviction proceedings, direct appeal. When the defense appeals from conviction at trial. Appeals are based on matters of law, not fact. Some vocabulary under post-conviction proceedings. The defendant on appeal, the name of the defendant who's on appeal is called an appellant. The prosecution on the appeal is called the respondent. The trial records are called clerk's transcripts. And the word-for-word record is called the reporter's transcript. I'm not testing you on those terms, but that's just FYI. Slide 20, the appeal. The first appeal is typically granted as a matter of right. Each side submits written arguments for or against the appeal, and those are called briefs. An error does not mean that you get a new trial, but it must show error affected the verdict of the trial. If not, it's just called a harmless error, and the conviction stands. Discretionary appeal. A second appeal is to the higher court. An appellate court has an option to hear that appeal or not. Let's look at page 38 of your textbook. A conviction can be reversed on appeal, so defendants frequently do appeal. Conviction eliminates the presumption of innocence. Therefore, the defense bears the burden of proof on appeal. Remember that. The prosecution bears the burden of proof for the initial trial, but it's the defense who bears the burden of proof for the appeal. Cases are rarely reversed if the defense bases its appeal on the credibility of witnesses. If a case is reversed on grounds of insufficient evidence, the legal consequences are the same if the jury had acquitted the defendant. The prosecutor cannot refile the case, double jeopardy, they cannot. Most appeals are based on legal problems with the case rather than the sufficiency of evidence. And let's go ahead and look at examples of issues that can be raised on appeal. Confession obtained in violation of Miranda. Search violated the Fourth Amendment. Improper jury instructions given by the judge. The judge improperly sustained objections and refused to allow a witness to testify on important questions. The judge improperly overruled an objection and allowed a witness to testify about highly prejudicial material. Those are examples of issues that can be raised on appeal. Examples of issues that cannot be raised on appeal: a weight to be placed on the testimony of the individual witness, that's up to the jury. Credibility of each witness, up to the jury. Possible testimony of witnesses who were not called during trial. Issues that were not raised in the trial court, and why the defense attorney used unsuccessful tactics. That's not something that can be used. The basic rule is a person who's been convicted is entitled to one post-conviction appeal, referred to as a direct appeal. The entitlement to one means that the court is mandated to hear the case.